Melissa Griffin. I'm a columnist who writes about San Francisco city politics, and I'm a member of the San Francisco League of Women Voters. I'm here today with the League and SFGov TV to discuss Proposition E on this November's ballot. Proposition E would allow the Board of Supervisors and the Mayor to amend or repeal initiative ordinances and declarations of policy that are passed by the voters beginning in January 2012. Initiative ordinances and declarations of policy are the only kinds of measures that would be subject to Proposition E. For 3 years after a particular measure takes effect, the Board and the Mayor may not amend or repeal it. After the first 3 years, the Board and the Mayor may amend or repeal the measure with a 2/3 vote of the Board. And after 7 years, the Board and the Mayor may amend or repeal the measure with a simple majority vote of the Board. Prop E would not allow the Board and Mayor to amend or repeal measures that the voters approved before January 1, 2012, or measures that the voters place on the ballot by collecting required signatures, or charter amendments and bond measures. I'm here with Supervisor Scott Wiener, member of the San Francisco Board of Supervisors, who is also a sponsor of Proposition E. Thanks for being here, Scott.
Thank you.
Why should we vote for Proposition E?
Proposition E is a very basic reform of our ballot measure system. Our ballot measure system in San Francisco and California as a whole is broken. There are too many things that go onto the ballot. There are measures that go on the ballot that should be handled at City Hall that we shouldn't be throwing at the voters. And then once measures are passed on the ballot, we have a rule in California, and we're the only state in the country that does this, where that measure can never, ever be touched, not even moving one comma after 30 years have passed, without going back to the voters with yet another ballot measure. It's a completely rigid system. It doesn't benefit anyone, and it's bad government. And Prop E would basically balance that out just a little bit by saying that for ordinances that are put on the ballot by the Board or the Mayor, this does not in any way affect signature drive ballot measures. So when the Board or the Mayor puts something on the ballot, an ordinance, that for the first few years, for the first 3 years, it would be untouchable by the Board. For the next 4 years, the Board could amend the measure with a supermajority 2/3 vote. And then after 7 years, the Board could treat the legislation like any other piece of legislation, subject to the legislative process. This is how it's done in every other state that allows voters to legislate, except California, and I think it's just a good government measure.
Can you think of an instance where, had we had Proposition E in place, the voters would have not had to go back and re-vote on some cleanup legislation?
Sure. Well, if you look at Prop F that's on the ballot right now, which is an amendment to the political consultant ordinance, we're asking the voters, among other things, should political consultants have to file with paper or electronically? Should they have to file every month or every 3 months? And I think most voters, if you ask them, would say that shouldn't be on the ballot. That's the kind of legislation that should be handled by the Board. But we have to put it on the ballot because the voters passed the original ordinance. I also have been working with both tenant and landlord advocates to clean up the rent control ordinance so that it reflects accurately what courts have ruled. Because courts have struck down some of our provisions, but the municipal code is inaccurate because it doesn't reflect those court rulings. So I worked with tenant and landlord advocates to try to come up with a cleanup legislation. And it turns out we can't do it because most of those provisions were enacted by the voters. So even if a court strikes something down, we can't even clean up the municipal code to reflect that without going back to the voters. It doesn't make sense.
Well, now, what do you say to voters who are nervous about giving over the power to amend something that they have passed at the ballot to politicians, to members of the Board of Supervisors, and to the Mayor?
Sure. Well, first of all, Prop E only affects a small percentage of ballot measures. It only impacts at most 20% of ballot measures. 80% are completely off limits. It also does not in any way allow us to amend measures that were placed on the ballot by voter signature, and that's really at the heart of the voters' democratic powers. What this does do is say that when the mayor or the board puts something on, we need to have some flexibility after the fact. And we see a lot of times the Board of Supervisors puts measures on the ballot that are not well thought through, that have come out of no public process with no prior scrutiny, and then the voters have to vote yes or no, and they can't say, well, I sort of like it, but I want to change that. It's an up or down vote. And if they vote yes, then it can never be amended again except going back to the voters, which in reality just doesn't happen because it's too difficult to put something on the ballot and run a campaign for it. So this is a very, very limited, very, very modest good government measure that really does continue to respect the will of the voters.
Thank you very much. Up next, we'll hear from an opponent of Proposition E. I'm here with Eileen Hansen, a former member of the San Francisco Ethics Commission, where she served for 6 years. Ms. Hansen is an opponent of Proposition E. Ms. Hansen, thank you so much for being here.
You're welcome.
Why should voters vote against Proposition E?
Voters should vote against Proposition E because it takes away the rights of voters. And so this is a perfect example of the voters being able to have their say and vote. And Proposition E is a measure that, once the voters have spoken, amends that decision or repeals that decision. So this measure actually undoes what the voters have said, and that's not appropriate in my view, or in the view of many, many, many who have come forward to oppose Proposition E.
Persons who are in favor of Proposition E argue that it's limited in scope. It doesn't apply to charter amendments or ballot initiatives put on the ballot by voter signatures, and that it only applies to approximately 20% of measures that are passed by the voters. How do you address that issue?
It applies to every measure that was put on the ballot by the mayor or the Board of Supervisors, and while it doesn't apply to measures that were put on the ballot through signature gathering, it applies to very important measures that came to us through our elected officials. And again, once the voters have spoken, regardless of how the measure ended up on the ballot, who are we as elected officials, anyone who's elected, to undo the voice of the voters? I believe that democracy is about the voters' choice. And once the voters have spoken, that is the end of the story. There are plenty of measures that I personally disagree with, that I wish hadn't passed. And what do I need to do about it? I need to work on getting those measures to come back to the ballot. I need to work with my elected officials, but I certainly do not expect my elected officials to undo what the majority of voters have said.
Certain public officials who endorse Proposition E have said that they've done it in response to voter concerns and anger over having to vote for so many propositions over and over, and that the notion behind Proposition E is to allow the board to clean up certain ballot propositions so that we can cut back on the frequency and the number of ballot propositions that voters have to contend with. How do you address that issue?
You know, certainly some people are concerned that our ballot in California is too long. I have not heard any good government advocates say that. I actually haven't heard very many individuals or haven't seen any organized opposition to our ballot. So I'm concerned that this measure comes really not from voter advocacy or voter concern, but comes from people who believe that the voters should not be the folks who have the ultimate choice. And to me, that's arrogant. It's patronizing to voters. The message about Proposition E, sponsored by Supervisor Wiener, as well as Proposition F, sponsored by Supervisor Wiener, both come from the place of saying that elected officials know better than the voters. And whether there's too much on our ballot or not, the voters, it seems to me, should not be talked down to, should not be told that they need a measure like this because, as Supervisor Wiener has said, the voters go to the ballot. It's a complicated ballot. They don't know how to understand the ballot. There hasn't been a lot of vetting of the issues, hasn't been a lot of discussion before things get to the ballot. And so the poor voters get to the voting booth and just don't know what to do, and it's not fair to them. Well, I believe that the voters, particularly our voters in San Francisco, are very educated, are very knowledgeable. They believe in democracy. They want to vote on measures, and they don't want to be told that they're not smart enough to figure out what to vote for and what to vote against. So once they have made that choice, we need to respect that choice.
Thank you.
Thank you.
We hope you found that informative. For more information about Proposition E and the other ballot arguments, please visit the website of the League of Women Voters at sfvotes.org. Remember that early voting is available Monday through Friday at City Hall, 8 a.m. to 5 p.m. And if you don't vote early, be sure to vote on Tuesday, November 8th.